Call the meeting of the fiscal court to order. Welcome everybody here this morning. First, Lisa Carter, our assistant county attorney, has been working on a issue that I think has been settled. So Lisa, you want to report the court?
Judge, I do. As you know, there was a dispute and actually a lawsuit filed centering on two unpaid property tax bills from 2006 and 2007. These were tax bills that became delinquent in a citizen's name, but after they became delinquent, the Marshall County Board of Education purchased the property, and a dispute arose on whether those prior tax bills would be exonerated because the school board is a non-taxing entity, government entity, and does not have to pay taxes. The dispute centered around the fact that a third-party purchaser had came in and purchased these old tax bills at the delinquency sale that they have every year. This matter was fully briefed and litigated in circuit court, and the judge ruled, our circuit judge ruled that he believed that in following the Kentucky Revised Statute that the county would need to refund the purchase price of those tax bills that were sold to the third-party purchaser. We were prepared to do that, but the third-party purchaser appealed this to the Court of Appeals because they wanted fees and attorney's fees and interest and felt like that they were owed much more money. At the Court of Appeals pre-hearing conference, we were able to settle this matter for an amount less than we had at risk if we would have been ordered to pay attorney's fees and interest, and we settled it in line with what the circuit judge ruled that we were going to owe. And so this matter is settled, and I will continue to work with county officials in getting the settlement documents prepared and doing the things that we need to do to make sure that these taxes are released and that the lien's released and that the school board has clear title.
All right. Any questions for Ms. Carter? Trudy Patterson?
Hi.
Hi.
I don't know where I should
Right there, Trudy.
Oh, the microphone right here. I see.
Sure.
Okay, I've never been here before. My husband, why don't you come up here? And I live at Rocky Point, just outside the point. Let's see, our house is where? Is right here. Right here? The point? No, I'm sorry, right here. And we and our neighbors would like to respectfully request that the speed limit there be reduced from 55 to 35. We have signed petitions from all of the people on the main road except for one house. Yeah. We couldn't find them. The reason is that, first of all, we live really close to the road. I have some pictures. Our house is 42 feet from the road, and sometimes when my husband is out there watering our trees, the traffic gets a little close. And also, I don't think that they're abiding by the 55-mile-an-hour speed limit anyway, because sometimes it's like a quarter mile out there and the light turns green and it's burned rubber. So we would like to request that the speed limit be reduced. Can I submit these?
Yeah, I guess, I don't know. What do we do? We have the petition?
Okay.
All right.
All the lots now are occupied by homes, and there's children,
And dogs and animals and...
pets, things like that. That's probably what we need.
Very familiar with Little Bear
Oh,
Highway.
you are?
Yes.
We were thinking, we were,
Now,
I have a copy of
at
this.
one time, is this now being maintained by us or the state?
Us.
At one time, it was state maintained, but we are maintaining. The Little Bear Highway, and I guess we're talking about from the church.
No, just the point.
just this
Just-
point development, this is a fellow named Charlie Evans. He's the last one in this development. The Duke Sons over here, they saw that. But just the Browns place over here. Just from, say, 50 yards, reduce it to 35 while over here, and back to 55, as soon as they get beyond that section.
Russell,
Sure.
let them show you exactly where they're talking about.
Okay, this is the last house on Bear Highway. We were thinking maybe 50 yards up here, put a stop sign, or not a stop sign, a 35-mile-an-hour sign, and there's a this is a little bit, okay, there's a 55-mile-an-hour sign right here out in the park.
Here's another copy if you'd like.
It's just right in here, Miller Road. B. Miller Road.
There's a road now.
Well, Brown used to have some property over here.
On this side, there are just 3 houses on this side.
Okay.
And then,
Is that down there where the day park is? right
yes,
there?
yes, that's where.
And you say there is a 55-mile-an-hour sign coming out of there?
Yeah, there's a, yeah.
It's on the first
It's
line.
right in front of our house.
I didn't do that.
It's kind of silly, but in any case, yeah, it'd just be for this section here. Even people dragging boats down here are going really fast.
This is our house, and there's a 55-hour speed limit by our mailbox. 42 feet from our house.
We don't know, we can leave with you folks. I don't know how
Yes,
to do this.
now Judge Miller.
Everybody signed. In fact, if I went to the houses and the wives were there, they wanted to sign too. They were really
So everybody,
kind of
How many feet from the day park to where y'all are talking about do you want?
oh,
Where you talking?
Well, let me make a suggestion, because I don't think anybody, I'm not trying to speak for the court, but I don't believe anybody would object to us lowering the speed limit to
Just in-
35. But probably it'd be a good idea, Russell, for you to go out and meet with these folks and measure it, like Kevin said, so we'll know exactly where to begin the 35. And then so we can properly sign it, say, speed zone ahead or
Oh, yeah.
reduce speed ahead.
Yes.
To give them warnings before it drops from 55 to 35. Now, like you said, or maybe it was you, they don't obey the 55, so I'm not so sure they'll
Well-
obey a 35, but I have no objection
As you-
trying anything to slow traffic down.
Right, and do understand if the court decides to lower it, we will have to give folks a grace period to get used to it. I mean, we can't immediately,
Oh, I
just,
know.
you know,
Yeah.
within
Oh,
a
no.
week of
No,
putting it
no, no,
up,
no.
you know.
well, as the judge had mentioned, it would be a good idea to have a warning sign anyway coming
Right.
down there, because we've had to pull people out of the drink.
Yeah.
The cars,
Yeah.
are they just go off the
This
edge.
goes down to our day use park, for people that are not familiar, there at Rocky Point. And gets quite a bit of use and a lot of traffic on that road.
Oh, yeah.
It really is.
There's a lot of slow traffic too.
Yeah.
A lot of the old folks up the road are using golf
Golf carts, yeah.
And,
And there's a lot of walkers in the summer too,
Walkers.
especially.
Oh, I'm sure, yeah.
Don't we have to do an ordinance? Isn't that,
Yeah, we'll need, if we're going to reduce the speed on a portion of the road, we'll need descriptions so we can put in the ordinance
Yeah.
exactly where.
That's why I
Yeah.
was asking the distance.
Yeah.
Just talking with Russell, I don't have a problem with that. I think that'd be a good idea, because that is kind of a congested area down there.
Yeah,
before you get
I
to
don't
the
think
Days Park.
anybody would object. We just need to have Russell get with the Pattersons and get the description, get with our legal department and get the proper description, and then if it takes an ordinance or the ordinance, try to have that ready for the next meeting, or at least the first meeting in September. If that would- so, Russ, if you could get their name, and I've got their, get their contact information.
362 8797. Yeah, I'm there most of the time, so.
Okay.
Is that all?
That's
You
it. Well, why don't we keep
Yeah.
the petition to go on file? And would you want the pictures as well, or just?
No, I don't need it. I just need the description.
Yeah, and then we can get them back to you.
Oh, that's okay.
Keep it in ordinance file, and then we'll get them back to you.
They can keep it.
And,
I just have to make copies of them. That's it.
No, you can keep, that's okay.
all right, thank you.
Thank you.
Our Parks Director, Mr. Larry Witt.
Couple items this morning, Judge, Commissioners. At our last court meeting, Commissioner Gold had brought up there might be some funds available for resurfacing of our walking trails, that he talked to someone in Frankfurt. After talking with them in Frankfurt, there are funds available, but it's a 50-50 matching grant. is why,
Found that is 50.
it wasn't 100%, they said if it had been 100%, it'd been gone quickly. That we don't have that budgeted this year, so maybe next year we can either put that in our budget or do a partial, but that's something we'll need to keep in mind and apply for if we want to do that for next year's budget.
What was our total?
$121,000 to resurface the walking trails.
Is it possible to do, like we had talked about before, like the public-private partnerships where you could have area businesses sponsor a section or organizations sponsor a section of the trails?
That's something, we can look at. That's something that, in our bylaws at the park, there are some conditions on doing some things like that. So that's something I'll need to take up with the park board on that, and those would have to be changed before we do anything like that. But second item is on our budget this year. We had it for a new vehicle. I just want the permission from the court to go ahead and advertise for bid for a vehicle for the park.
When you say vehicle, we talking about a pickup truck?
Yes.
All right, you've heard Mr. Witt, request to advertise for a new vehicle. Motion. A motion, is there a second?
Second.
Motion and second. All in favor of the motion, say aye.
Aye.
Opposed, no. Motion carried.
Thank you very much.
All right, anyone else here to address the court? All right, let's move into correspondence. We received word from the UK Healthcare Center for Rural Health. In fact, our young lady came in to see me about a week ago and said Home Place was shutting down. And then I got this letter from Larry Quillen. Over the last several years, the Kentucky Home Place program has endured several reductions in funding. Unfortunately, for fiscal year 2015, we have seen yet another reduction to the funding that is vital to the sustainability of our program. Regretfully, these cuts in funding have made it impossible to remain a statewide presence and have made it necessary for us to make some very difficult decisions. As a result, we have no choice but to close many of the offices in which our community health workers are located. Because of these closures, we will be vacating our Benton, Kentucky site located at 1101 Main. We are making every effort to be fully vacated by Friday, August the 8th. We are extremely grateful for your generosity in allowing our staff to have office space in your facility. It is because of this generosity the program was able to sustain itself over the past few very difficult years. If you have any questions or concerns, please do not hesitate to contact me at 606-439-3557. I think they've already vacated the office. Of course, we had provided office space for this program free of charge since the inception of the Home Place program. And they were able, and the gist of their program was to help particularly seniors get their medicines at a very reduced and sometimes without cost. So this is really a blow. I've had several calls from people. I do not know whether they're closing all of the offices in West Kentucky because they had an office in Mayfield, Graves County, Callaway County, River counties. So I don't know if this means all of western and south central Kentucky will be closed, but it's going to hurt a lot of people because they depended on this program. From the Department of Libraries and Archives, I'm pleased to advise you that your application, this is to Tim York, our county clerk, your application for a grant from the Department of Libraries and Archives Local Records Program has been approved. A FY 2015 Local Records Grant Award of $41,710 is being made to provide funding for equipment for the clerk's office. The award is contingent upon the availability of state funds. Prior to the commitment or the commencement of your project, staff from the local records branch will be in contact with you in regard to completing the agreement between the department and your office. So that's good news. I know Tim was delighted to hear that. From the North Marshall Water District, the Marshall County Fiscal Court, by action taken by North Marshall Water District Board of Commissioners at the regular monthly meeting on July 22, 2014, North Marshall Water District hereby requests an additional extension of Raceway Lane by 225 feet under the county road system. The North Marshall Water District will grant any additional easement as needed. This is to complete, and I believe, Larry, I'm telling this correct, another entrance into the park, provided that we are successful in obtaining the properties that y'all have made an offer for already, or?
Yes, sir. Actually, the easement, the road stopped before the North Marshall
Yes, that's,
purchased the property, and they were gonna extend it a little bit, so they wanna go ahead and extend it. I think this right lead it all the way to the end of that property. So
Yeah.
that we can get an easement going across it to the new property that we're
Yeah.
going to purchase.
okay. So I guess what we'd need is the court's consideration on extending that Raceway Lane by 225 feet. What's your pleasure?
What's the, you mean paving, extending,
No, just extending the right-of-way.
just the right of way? So
Yes,
we're not
so
talking
they-
about any maintenance, because
No,
there
we're not
was
talking about any
discussion about.
maintenance until such time as a lot of things can be worked out. This
Okay.
is
In the
just to
future,
clear it
though,
up.
There will be some road work.
This would purchase the property, get another easement into the property, we would need this extension. Of course, that's all, I think that's all in place,
Yeah.
but action.
Yeah,
I just remembered some conversation about on down the road. I wanted to make sure we weren't talking about that now. I'd make a
Yeah.
motion for the extension of the right of way.
all right, you've heard the motion by Ms. Drew. Is there a second?
Second.
Second by Commissioner Gold. Any discussion on the motion?
And then-
Hearing none, all in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. Next is from the Marshall County Conservation District. This is for the Certified Agricultural District. This letter is to inform you that the landowners of Certified Agricultural District number 079-02 have asked the Marshall County Conservation District to recertify the district, which is located southwest of Benton, adjacent to Highway 641 bypass. KRS 262850 requires that the Conservation District notify the local regional planning and zoning board as well as the fiscal court. Please find the enclosed map denoting the boundaries of the agricultural district. If your organization has any comments concerning the recertification of Certified Agricultural District number 079-02, please contact the Marshall County Conservation District within the next 30 days. And this is Kyle from Chairman Kyle Odell. It has it all marked out. If anyone has any comments you'd like to make, we'll make copies for everybody. That was just for our perusal, I suppose, because they didn't ask us to make any motions or take any action. Any other correspondence for the court? All right, let's move into old business. You've all received the minutes of the July 15, 2014 meeting. Any corrections or additions to the minutes of the meeting?
And then,
And make a motion to approve the minutes, Judge.
Have a motion, is there a second?
Second.
Motion and second, all in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. Next is the second reading of ordinance 2014-07. This is an ordinance to reflect the requirement to post notice at the property site. This is an ordinance relating to the enforcement of abatement of nuisance pursuant to KRS 381.770. Be it ordained by the Marshall County Fiscal Court, Commonwealth of Kentucky, Section 1. The Marshall County Fiscal Court hereby creates the Marshall County Nuisance Code Enforcement Board and vests said board with all necessary powers to carry out its duties under this ordinance. The Marshall County Nuisance Code Enforcement Board shall be comprised of, at any given time, the then sitting members of the Marshall County Refuse Board. Pursuant to KRS 381.770, this ordinance is being enacted to establish procedures for the enforcement of KRS 381.770. The Marshall County Sheriff and the Marshall County Nuisance Code Enforcement Board are hereby appointed to enforce this section by and through the powers of their offices, the powers granted to them by KRS 381.770 and this ordinance. Marshall County Sheriff shall create forms necessary for complaints filed with the general public pursuant to this action and be responsible for the maintaining of all records of filing pursuant to this ordinance.
Judge, I'd probably say some reading. We just made that one change, so if you just wanna go.
The one change is
Item 7.
item 7.
I think.
Well, since y'all have been very wordy in the creation of this ordinance, I would be very happy to summarize and go to section 7. 6. No, 7.
7, okay.
Notice shall be, don't confuse me, I'm old.
I'm confused.
A notice shall also be sent to the last registered and legal owner of record of any items located on the property where registration and documentation of legal ownership are applicable unless the owner is the owner or occupant of the premises wherein the nuisance is located, unless identification numbers are not available to determine ownership of the vehicle or the property is of such there is no documentation of ownership. The notice to abate and the right to request a hearing shall also be posted on the property itself in a conspicuous location and fastened to the property in a secure manner without damaging the property no less than 10 days before action is to be taken. And the Marshall County Sheriff shall make an affidavit attesting to such facts. Where property that carries a registered title or registration of ownership is found to be upon any public property within the county, notice the owner is all that shall be required. Where property that carried no evidence of ownership is found on public property, no notice shall be required. This all has to do with trying to clean up some areas of the county. We've discussed this at a prior meeting. You would think sending a registered letter to the last known address, which Kevin has done on each and every occasion, would suffice, but, putting this was just another step to try to make sure that the property owner has every opportunity to do what is necessary before we have to take it before the board and take action to clean it up. So, with that being said, I would entertain a motion to pass the second reading of ordinance 2014-07.
I'm sorry, Judge. Jason, that says no less than 10 days. which means, we had talked about the sheriff not having to make 2 trips, and that's what would happen if we stayed at less than 10 days, because from the time he goes out and confirms there's a nuisance, if it's gonna be posted, it would be posted at that time, but that's not necessarily within that 10-day time frame, right?
If I post it, I'm assuming the 10 days start counting when I post it.
That's right.
And then that would coordinate, would the notice have to be sent out that day? Okay, so it can be posted then? I just don't want you to have to make 2 trips. Okay,
I don't see any reason why it couldn't.
okay. All right. I make a motion to accept the second reading.
Have a motion, is there a second?
Second.
Motion and second, any discussion?
Judge, why can't we eliminate the refuge district having to deal with this? I think the sheriff's qualified to come and report to us that there's a nuisance without going through all those extra steps, and it's causing people to not want to report these things because it's such a long, drawn-out affair to get something done. Why can't the sheriff post that and report those photographs and findings of his straight to the fiscal court, and let's take action and eliminate all this hoopla in between? Because all it does is a delay.
Well, this is how it was set up in the ordinance, I assume, and
I mean,
this
the
is going-
statute just gives the county authority to set up an enforcement mechanism. So, I mean, if you want to,
I mean, I know they do. I mean, we could have them to see the refuse board and the water board and another 2 or 3 boards before it comes here. But my point is, I don't see the importance of that. I think the sheriff's qualified to take photographs of a place that's being complained about, and that be brought directly to the fiscal court for action, instead of going through all this stuff that takes 6 months to get something done, and people become frustrated over that. I've dealt with
that's up
this
to
for
you guys.
25 years.
if you want to do it that way, you can.
I mean, if the photographs are presented and the sheriff posts can we not look at the photographs of that property and determine if it needs cleaning up? Why do we need a board to tell us that that's the case? And if they should ask for a hearing, they could do it before us. And there's no reason to just have one more step for those guys, for a citizen to take to get this taken care of.
You can set
That's
up
my
however
opinion.
you want to, as long as there's some
There's
monitoring
gotta
and
be
due
a
process.
mechanism in which, and it could be the fiscal court,
Right.
or it could be the refuge board. As we set it up, my understanding, if we set it up, that if there is a plea for a hearing, that the place to go would be the refuge board. Now, if you want to change that to make it the fiscal court or whatever, but you have to have a mechanism, and I understand the law.
You just have to have notice and opportunity to be heard. That's the 2 requirements of due process, so. You
They've
can set
been
it up however you
managing,
want.
they've been helping to manage that process. I mean, that was what they were set up to do, to help manage that. And,
What are they managing?
well, I mean, I know that, Troy's been reviewing those sites at their behest.
I feel quite certain the sheriff's qualified to photograph a place.
Well, I
We
understand, but
look
that's
at
during the cleanup. He don't need to go back out there and continually look at places. to see
Russell
if
will
they're
be the
being
one
cleaned
cleaning it up. But if we clean it
If
up,
it's
Russell will do that.
contractor's been cleaning them up.
And then, so it's just another step that people have to take, is it just drags it out. And that's the frustration that people have, is it takes so long, once they complain about something, a year's passed and it's still there.
And it's the same, I mean, it's the same time frame, isn't it? I mean, give so many days to have a hearing, and if you don't hear from them,
Well, statute sets that
then we
out.
can take action.
But we don't. We haven't, because they're still there. Those places still exist. That's the problem. People become frustrated over that. I just think it's an extra step that the citizens shouldn't have to take, but that's my opinion, so whatever.
Okay, I
Well,
don't know.
since this discussion has come up, I'll just take it one step further. In my opinion, since the state is mandating us on all of our inspections and stuff for residential and commercial whatnot, I think the county needs to explore zoning again. And that would take care of this issue altogether, because they would be an actual entity that would do code enforcement at that point, and that's all they would take care of. So I don't know if the court's interested in doing that, but I think it's worthy of discussing again and possibly looking at zoning throughout the county. I know that's not popular, but that would expedite that process, in my opinion, if you did have that in place, because you look at the cities, they're doing, they have an enforcement mechanism that they do that law enforcement has nothing to do with. They have their own entity that looks into that and takes care of that. And
I agree. I mean, I've said it since I've been here, that I think that the process that we have is cumbersome, and we've only made progress the last year with addressing any, but we talked about limited zoning. We talked about limited zoning that would only enforce the state statute that's already on the books as it relates to nuisance properties. And the discussion never went anywhere, but we could do that and create the code enforcement board that would not involve your office and cost you all additional funds and time. I would definitely be in favor of it. But
like I said, just something to talk about and discuss. I mean,
it's not
have to see
creating
what
any new zoning or ordinance, it's just enforcing a statute that's already on the books.
Well, no, you'd have to go another step if you're gonna have zoning, whether it be limited or whether it be full-blown. There's steps that would have to be taken. You can't just say, we're gonna zone this part and this part's not, I mean, you know.
No, yeah, I'm
it's
saying
more
that the board would
complicated than
enforce,
that.
yeah, they would enforce what's
Yeah.
already on the books. We wouldn't be
Well,
trying to monitor the
We
height
can
of the
enforce
grass.
what's already on the
Yeah.
books now,
Right.
and that's what we're doing.
but I
That
think
wouldn't really be
discussion.
zoning, that would
No.
just be creating an enforcement board to take care of
Yeah.
38177.
And we can do that. I mean, it don't have to be the refuge board. We just set those, that's who's been doing it.
I guess, I mean, we wouldn't have to have kill, I think, I don't know, that when they decided to do Kevin's office or the sheriff's office, that people were more comfortable in going down and, you know, feeling like they could sign a complaint. That was kind of where they felt like they could go, and maybe that's not the case, but you could have the refuge board right now as that complaining
Here's my issue with it.
position.
And this is a touchy subject because people do want their neighborhoods and their communities to look nice. It is important to them, yes. I've got a full plate anyway. And just to be honest with you, I get to them when I can. It's not by my choice, because I've got other things that are pressing, more impending, that needs my attention other than the nuisance ordinance.
You understand?
And therefore, I get to them when I can, because I'm the one that does it. I'm not gonna ask any of my people to do it because they got more important things to do. And that's part of the process too, is folks have gotta wait on me. And I'm sorry, but that's just the way I have to do it, is I have the time to do it and get to them.
Okay, any other discussion? We have a motion and a second on the floor. Adopting the second reading of ordinance 201407. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. At our last meeting, we took bids about creating a county website. And our computer folks, some of them were on vacation, so we asked that they look over those bids. Are you ready to make a recommendation or no recommendation, or just what are we
we're
doing?
making a no recommendation. We're electing to refuse all bids, and the way we're gonna go forward is to handle the majority of it in-house. And the small portions that we can't do or that we don't have the time to do in-house, or if there's somebody else who has a specialty in that area, then we'll find somebody to handle those portions, rather than the whole project. And the reason behind that is we really looked through all of the bid proposals, and none of them really addressed and kind of drew a picture of what we were looking for on our website. So I think we're gonna try to handle that ourselves, like I said, and then just handle the parts and pieces, maybe through third-party contractors.
So your recommendation is to reject all the bids?
Yes,
Because we took no formal action at the last meeting.
that's correct.
So your recommendation, any questions of Andy? Then I would need a motion to reject the bids and to proceed in-house.
I'd
If
make-
that's the
I
direction
mean,
we're going.
you followed up, you said that you were going to go through it extensively? I mean, you pretty well set out the parameters specifically?
Yeah.
Okay. If that's the recommendation, I make the motion that we reject the bids and go forward in-house.
All right, heard the motion, is there a second?
I'll second, but we need to be, I mean, I think everybody's in agreement, we need to be moving forward. Y'all are ready to do that, or you feel comfortable? A second, then.
All right, motion and second. Any discussion? Hearing none, all in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. At our last meeting, we had a public hearing on Quail Hills Road, Sparrow Lane, and Pheasant Lane. The viewers had viewed the roads and recommended that we not take them as is because they don't meet our standards. But, of course, after we had the public hearing, you have to hold it over till the next regular meeting of the court to take any action. So what is your pleasure?
Judge, I think we need to consider taking this, and I think we need to consider it for several reasons. One is our country's $18 trillion in debt, and we contribute to that debt because we spend federal funds in our community. And we can do this road cheaper. We mow less, we clean less, and it costs less initially to pay our half because this is an existing road. You stated at the last meeting that safety was the number one concern, which I agree with you there. It is. But if that be so, then we're worried about this road not accepting it because of a 30-foot right-of-way instead of a 40. Then we have many, I have a book right here, with many, many dozens of roads that are ditch to ditch, that are 20, 15, have 9-foot driving surfaces or one lane. So if safety.
And many of these were taken in prior to the ordinance that we put in place.
I understand that.
My point being,
I understand that, but Judge, if that's true, if safety is the number one issue, and we can't
I'm
take
not
this road.
saying safety is number
That's
one
what you
issue,
said.
that is an issue.
Is that what you said?
I
So,
don't know why I said that.
I watched
but-
it last night on the.
Well, I could have.
Okay, let's don't argue that point. But the point is, if we're gonna consider safety, then if we're gonna say this road shouldn't be considered because of that, then what are we doing with the other roads? You say Russell says he can't maintain this road because it has a 30-foot right-of-way. We have some that are ditch to ditch. So I'm saying that, that those things, that just doesn't add up. And the policy, violating the policy, we can clearly see that the policy has not always been followed. And the safety issue is not a factor here, because if it was, we would have to certainly be addressing all these other roads that we're maintaining that are worse.
I'm just,
But Judge, see, these roads
if we-
look, let's forget it behind us, let's say going forward. I think we should consider every road in the county, from this day
you
forward.
realize what it's gonna take to bring every road that you have voted
No.
against and everybody else has voted against.
I'm not saying those roads, I'm
Well,
saying
you know,
going forward.
if you cannot make an
Yes,
exception,
we
I don't
have.
think.
We have. So if
Well, the
we,
road you issued, you
if we take in,
mentioned right
I'm
there,
saying
and
if
I'll
we
talk about
take in
that one
roads in
too.
the future, I'm saying if we take in roads in the future, if we could consider 30-foot right-of-way instead of a 40. I don't see the importance of how much grass we mow on the side makes that much of a difference in the safety of the road. I don't see that. I'm not trying to be difficult, I just don't see that.
Well,
If
I'm
it's-
just,
it
we
doesn't- it
said
doesn't
40,
matter.
at one time it was 60, then we went to 50,
Right.
and then we went to 40.
Right.
And the reason we arrived at 40 is so that we would have proper shoulders, proper ditches, and maintain the driving surface. Now, if we can work with these people to get them into compliance, I'm totally,
But what's compliance gonna be? That's what I don't understand exactly. This is an existing road. What is compliance gonna be?
well,
The
it's gonna
statute-
meet our standards. That's
Our
set out
standard
in
says
our,
it's an
it's
exist-
set out in our
An
policy.
existing road, they pay half, we pay half. And we don't consider the condition of the road when we do that. right?
Jeff, you'll have to answer
Yeah,
that.
what
It
was the
hasn't been
question?
done in the past. We haven't considered him, we didn't go count potholes in roads when we take them out. So the condition of it is the agreement is they pay half and the county pays half. I'm just saying to consider these roads, all of them in the future, because it's less cost to the county if we take roads in with a 30-foot right-of-way and a smaller travel portion, say 18 to 16 feet, because we have them now. In situations where that they are dead end, like at a lake, and they're short distances, because speed is not gonna be a factor. And so the safety issue doesn't come into play in this. And it saves money every day. It saves money every winter, every day, because it's less maintenance. It's less cost initially to put it in place. So if we go impose and make these guys give us 40 feet of right-of-way, that's all we've done. You're just gonna mow a little bit more grass. That's all, that's all.
Well, I'm just saying, the court has time and again rejected roads because they did not meet our standards.
Which may have been because they weren't paved, or it may have been because they
Or it may have been
didn't
because
have
not
enough right
proper.
of way.
That is correct. There's
whatever.
different reasons.
We've done it over, and I mean, since I've been on the court, we've pretty much
In
stood by
2000,
the.
in 2000, in the year of 2000, Walton Lane's blacktop,
Yeah,
all the way to the backside of it. It had not, our law says that if
Well,
there's no
I
homes on it,
checked on
it reverts
Walton
back.
Lane because I wasn't sure.
It reverts back, Judge, after 15 years, so that was not a county road any longer. The property owners owned that. But we
This was
blacktopped that.
Mr. Hargrove, and he said he paved it at
The
your
county-
request. That's what Gary Atkins
My
told me.
request was to close it.
I don't know about that. I'm just telling you.
Okay, let's say I did, request it. The county came out, they blacktopped the road that they didn't even own for 3/4 of a mile, one lane with no homes on it. Even if I requested or I didn't, so why did they do that?
Don't ask me.
Why are we
I let the
maintaining-
commissioners pick out the roads they want to blacktop, Terry. I always have. You know that.
Why are we maintaining roads now without homes on them? We spend money on them every year. They have no homes on them.
Well, also.
I'm through arguing.
And you
I
go
make a
the other,
motion
you
that
go
we-
the other
I make a
situation.
motion to accept these people's road because
right.
it's the right thing to do, and there's no reason to have 40 feet of right-of-way, and the safety issue does not come into play. It does not exist in this situation, and it's safer and it's cheaper for the county. That's why I want to make that motion.
You have a motion. Is there a second? There is a motion. Is there a second? Third and final time, the motion. Is there a second? Motion dies for lack of a second.
Judge, before we move on, I would like to see if maybe we can mitigate this, and I know that the property owners said that they would be willing to donate whatever land they needed to. There was only maybe 2 in question that could not. So if they would give the right of way, and we could make an exception for we can have variable right
I'll
of
be
ways.
more than happy, and I've talked to Russell about it, if we can sit down with the landowners and work out something that would work for everybody.
I mean, there's a couple
be
that
more than
can't
happy
give
to
it.
do it.
Their
I mean,
house
I'm
is
not.
too close.
Well, it
But
looked like, I'm not sure, but it looked like to me that a good portion of it you could get a 40-foot right of way, but it's not, I mean, there's not any ditches. There's just a lot that's gonna have to be done to keep it from, so you can maintain it. But it looked like to me you get quite a bit of 40-foot right of way, and if if they wanted to replat and get that, even if you stopped at those other places, we could take in the portions that meet the spec, and it would just leave a small amount. The end of that would be considered driveway or private drive.
I think so too. I mean, if it was a variable right of way, then work with the property owners that can do it. We take in that section of roadway and,
I mean, there's,
Well,
I mean, I would
think
work
we-
with them,
work
but
with
we
them
need
and
to
consider it for sure.
follow the spec. I feel like we've followed this spec, we've developed it, and we need to stay with it, or we need to change it. There's a lot of places right now that would probably put in if we changed it to 30 foot. I'm sure there's roads that people would come forward and want to put in because
So
that's what their
exactly my
plans
point,
are.
Bob. That's exactly my point. The reason we're imposing a 40-foot right-of-way on these people is to keep from fixing the road. But it's costing us money when we do that. So that makes no sense to me. That was my point.
do we have to have a 40-foot right of way?
That's
Is
what
that,
you're,
I know that's what the
We
local
don't have
policy
to.
Well, the
says. Is
spec
that,
is,
We don't
that's
have
what
to do
was-
that.
That's what's in here.
that's what was voted on with the court.
Right, there's no,
But we're
there's
not
no
bound to
standard
that.
for that.
I mean, that can be changed.
Sure.
But you need to change it for everybody. We just finished the road.
And it
Old
generally
Opal
has
Lane. We
followed
just did
whatever
Opal
the
Lane
minimum
and
for
took
the
it in,
state
but
roads
we
are.
put it up to that spec.
If they paid $120,000 to
They
get it to
paid
our
to get it
standard.
up to that spec.
But
If
it
we do a
wasn't existing road
subdivision,
either.
One reason that occurred is that there were times we trade roads with the state. And if you don't, if you don't have their minimum right of way, obviously that road doesn't qualify. And I think that was,
That was the original start, when we started with 60 foot, because the state required 60 foot. Then we went to 50 and then 40. It's been changed and it can be changed. But until it's changed by ordinance of the court, the ordinance that you have voted on is county law, if I understand it.
well, you've set specs. I mean, obviously, vote of this court changes that.
Sure, that's what I'm saying,
But
but
Jeff, we're not bound to that. That doesn't mean the fiscal court cannot accept this road. Is that true?
Well, you can go,
We can
if
accept
you
it. We can
state,
accept
you
this
can
road,
go
can
out,
we
you
not?
can change your rules and go outside that, yeah.
Right. We don't have to change the rule. We can just accept the road if we want to, can't we?
But if you're going to do that, you need to have there needs to be a reason, a rational and
That's
a
what,
reason to
that's what we are trying to
substantiate.
articulate here, is that because they're short distances, they're dead-end roads, and they're not likely to change. They're already built up with homes, the homes are there, and there's other areas in the county would be the same, and it just saves the county taxpayers money.
well, but if you make an exception for one,
but
then where does it end? I mean, you voted no on another road, or the court did, that has a lot of homes on it.
Where's that?
Opal Lane
Your district.
came up, I mean, it had
Where Jim
existing
Sires
homes
lived.
on it for years.
I didn't vote
And so's
no on that.
Tanglewood in my
Sure.
district, High Ridge Resort, I know I've just given them the information about being able to add the tax. They have a wonderful subdivision there with big wide roads, but they're not paved and they don't meet the county spec. I mean, if it doesn't meet the spec, you're talking about costing money, it would certainly cost us a lot of money to take those in and then have to do that work. But there's homes on a lot of these roads.
So it comes down to the 40-foot of right-of-way eliminates the county from accepting the roads.
Meeting the
That's
spec,
purpose.
40-foot right of way and
The spec
pavement
is not
and the
what's
base.
important.
I can assure you that, I was just over there, I mean, Quail Hill, the little Pheasant Lane, there's a root and, roots under the road pushing up the pavement. That typically means there wasn't enough base put in. I mean, it was probably
That's
just a
why
little
Jeff-
gravel road that's been paved over the top of it.
Bob, that's why it's called an existing road. That's why they pay half to bring the road up to the specification.
I don't know, I just,
Well, you do know.
follow the
That brings-
specs.
That brings it up. That is following the specs.
No,
If they-
it don't
if they-
seem like it
think
is
so.
to me.
I disagree, but
Well, Judge, the county, the property owner pays half and the county half on the existing road. That's how existing roads are taken in. That's what the ordinance says. But the only reason that these people are not getting roads is because of the 40-foot of right-of-way is ridiculous. There's no reason for that. It's cheaper for the county to not do that. And there's a lot of roads that are gonna be taken in that could be a 30-foot of right-of-way. Because most of them we have in this book right here are not, most of them are not 40 feet.
I don't know. I would expect that if that road was taken in, that an engineer would look at it and actually the pavement would be removed and there would be base put down before you ever did anything. You'd ditch it, put base down and then repave it. If you was gonna maintain it, the county was gonna maintain it going forward.
Could be.
okay, let's move on. Cable franchise. Jeff, you looked it over,
Jason and I've been looking at that.
Did you get a copy of the letter that I sent back to,
I saw where you had wanted some changes, but have you,
I haven't heard back. That was
but
the
in order to do this, we will have to follow the rules of the public hearing and some other things, will we not?
Right.
So you have not heard back from the letter you sent on July 29th?
No, sir.
Okay.
And I sent one a few days before that, I believe, asking the same, because it was the same contract that they sent for Hardin.
Yeah,
And I haven't heard back from either one of them.
okay. Well, we'll just table this until we hear back. The gun range survey, we got a bill from the surveyor that surveyed the property. I think we asked for it. And the gun range committee has since dissolved and sent the money back to all those folks. But since we asked the survey to be done, I feel like we're liable. I think it's $1,100, is that correct?
A little less than that, I think it's 1,050.
$1,050. Do I hear a motion, we pay that bill?
I'd make a motion.
Second, we,
Have a motion and second.
it's on our property.
Yeah.
also, so,
All in favor, say aye. Any opposed, no. Motion carries.
Do you think we need to make sure somebody has a copy of those survey results or something somewhere? I don't know.
Who has it? Is
I
that
have
what you
no
said?
idea.
Chris
Yeah.
Smithmeyer.
Okay,
He's the one that had it.
do we need to,
We need to get those so we can have them.
somebody have
in
that?
case we did it again, something else came up.
Frontage Lane nuisance property, I'm not sure.
Is that the one I forwarded you the email? This is a piece of property that you have began to do the cleanup work on. I got a call last week, and the lady, some issues about tearing the building down, or the garage, and so I told her to send us whatever she was, her position, for you all to review to determine how you want to proceed.
All right, this is from, I've got the letter here. This is concerning the property at 104 Frontage Lane, Benton, Kentucky. It was brought to my attention this week that when I didn't respond to the letter I received late last year concerning the cleaning up the back part of my lot, it went through the court system and had a bid received and approved to get someone in cleaning it up. This is my fault for not responding to the letter, and I accept that. At the time, I had only been with a new company for a year, and with money being tight, I did not have the funds to hire someone to come in and do it. A friend came over and started moving some stuff that was sitting around the garage while reminding my son, who was going to Daymar, that he needed to find a way to get the mess cleaned up from where he let someone take the metal off a shed we have back there. Unfortunately, that did not get done, and as winter came, I completely forgot about it, which again is my mistake, and I apologize. This year, between having repairs inside to make and appliances to replace, I've not had the money to fix my lawnmower and weed eater, nor do I have a chainsaw. So again, the back has grown up and stuff has not been removed. I accept the fact that it needs to be cleaned up, and I will pay for it. While it's an embarrassment to have it done this way, it needs to be done, and hopefully I will be able to make payments on it. Once I get past this, hopefully this will be all that needs to be done, and my lot will once again look presentable. My problem is, in the bid that was accepted, it was said to tear down my garage, and I think it gives the person the right to remove an old car that is sitting there. The garage is still used for storage. It may have holes in it, but it is in no danger of falling down or in, and there are still things in it that was put in there when I had a house fire 10 years ago. My goal was, and still is, to be able to eventually afford a small shed to move in there and transfer the things from the garage to it and then tear it down. That, though, will be a couple of years before it can be done. My son just went to work part-time, and I'm also surviving on I am single, so surviving on my income. All of this is just excuses, I know, but unfortunately, it is my situation at the moment. The car that is sitting there was driven by my son until last fall, when my dad gave me a car to drive and my son took over my older car. Last I knew it was still drivable. Last I knew it was still drivable, but the key was lost. The title to the car is in my stepdad's name, so I really don't need to have someone taking it off. At the moment, I'm trying to come up with a cheap means to get the car moved, even trying to find someone who can hotwire it. Sheriff, I'm assuming you know several people who can hotwire the vehicle for them.
I know one or two, maybe.
Yeah, that's what I thought. So I would like to ask that you please not tear my garage down and take the car off. I understand it's gone too far to stop anything from being done, even if I promise to work on getting it cleaned up, which would take time to get people in to help me, as I can't afford to hire someone. If for some reason you do decide the garage needs to go, I respectfully request that you give me a couple of weeks to move the stuff out, which means I need to find somewhere to put it. Any help you can give me, though I know I'm late in asking, would be greatly appreciated. If you would notify me of your decision, I would appreciate it. Thank you for your consideration. I mean, you sent the required notice over a year ago, didn't you, Caleb?
Mm-hmm.
And you never got an answer.
Well, actually, what happened, they did start some work on it after they got the notice, and you could see a noticeable effort to clean up, and it stopped. And I checked with county attorney, I said, do we have to reissue notice? He said, no, not at that point, and we can proceed on, and that's why I turned it over to the court, because it stopped after a couple of weeks. And I had folks revisit with me that put the original complaint in, saying what's going on with it, so that's where we're at.
Well, it appears to me she's had a lot of time. If the court would like to give her a couple of weeks to get stuff out of that garage, I have no problem with that, Jeff. I guess you'd need to contact her and what do y'all think
Tear the
would be?
garage down. I believe all she's really asking is that we don't tear the garage down.
Right.
Was that part of the original complaint?
Mm-hmm.
It is.
Well, she asked that we not tear it down and then says she needs time to get stuff moved out of it before we tear it down. So
Kind of contradicts itself there a little bit, because it said it'd take 2 years and then said give her a couple of weeks, so.
yeah. Yeah, she's had 2 years, so. Whatever y'all wanna do. I mean, I don't wanna be unkind but I'm like Kevin, we've given 2 years and so.
So there's an existing structure. I don't remember which, most of the other ones.
It's a concrete block building with a roof on it, and yes, it's got several holes in it where blocks are missing. There's quite a bit of stuff strode all over the yard. Like I said, the old car's sitting there.
But I mean, is there still an inhabited structure on the property? Everything else that we've done, it's been vacant.
I don't think so. I believe the only thing that's on that lot is actually that storage
all that's
building,
there.
if I'm not mistaken.
So that's the whole complaint. It's not like there's an existing structure.
Yeah, I think, as you alluded to, there was a fire there, there was a structure there, it burnt, but this was what was left. And I think she lives at another location, if I'm not mistaken. Like I said, after so many of those I do, I can't remember all the details, but from what I remember, I think it's just that structure and all the debris that's there on the lot.
Would the nuisance be abated if it were cleaned and the structure remained, or do you believe in your opinion?
That's up to y'all. I mean, You know, I'm no inspector to know condition of a building,
I don't know.
so I can't make that recommendation.
Can we start there? There's nothing to keep us from having them clean up around the building and to give them whatever time, you know, short period of time, get it cleaned up. Leave the building for the time being, tell them that, you know, we'll make a determination later then whether to go ahead and tear the building down. I hate to,
Well, since we're giving them 2 years, I'm not
think it-
giving it. Appears to me they've had ample notice, but
the other would
that's
be
all right
then
with
to
me
just give her a
try
couple of
again.
weeks to get the stuff out of the building and then let the contractor take everything out.
Time before.
I mean, we can give them 2 weeks, because if we're gonna do something, we gotta put it out for bid anyway. And we've got
It's
to
already
run
been
it.
bid.
It's already been bid.
It's already been bid.
Has it? Oh, okay. This one's already on the, okay. You wanna give them a couple, I mean, what do y'all wanna do?
I mean, if you're leaving the garage, do you have to
We're
rebid
not,
it since it's?
well, we're not leaving the garage, we're just trying to give them time to get stuff out of it, if I understood y'all correctly. Cause she said she had stuff in there.
I'd make a motion, I guess, that we give her 2 weeks to get that's what she requested out of the structure.
All right? Is there a second? Give her 2 weeks to get her belongings out of the garage.
Second.
Motion and second. Any discussion? Hearing none, all in favor of the motion, say aye. Aye. Any opposed, no. Motion carries. Mr. Attorney, would you let them know we've got a number there you can call if they have 2 weeks? All right, we have an update on nuisance property across from the county park. There has a fence been put up. I haven't been by there, but does it pretty well conceal everything?
Yeah.
So about a 6 foot,
All right.
maybe 8 foot.
The Maggie Street cleanup is complete. This is down in Gilbertsville. The double wide there has been removed, the debris. And we've got pictures of everything there. If y'all wanna take a look at that, then the Hall Drive cleanup, all the properties on Hall Drive have been removed and cleaned up. So progress is being made. To this point, so appreciate the work everybody's doing. Any other old business? All right, let's move into new business. We advertised in our paper of record, the Tribune Courier. Marshall County Fiscal Court will accept sealed bids until 9 a.m. on Tuesday, August the 5th for the construction of a county road which will connect Oak Level Road and Simpsonia Road, a distance of approximately 3,200 feet, less a 30-foot bridge. The road will have a 24-foot driving surface, 3-foot shoulders on each side, grade and drain, and a 3-inch bituminous asphalt surface as specified in the plan. All bidders, including subcontractors, must be pre-qualified by the Kentucky Department of Transportation, and the bid must be accompanied by a bid bond and proof of insurance. Plans and bid packets may be obtained at the Marshall County Executive's Office, 1101 Main, Benton, Kentucky, Monday through Friday between the hours of 8 a.m. and noon and 1 p.m. to 4:30. The Marshall County Fiscal Court reserves the right to reject any and all bids. Is this the only bid?
Yes, sir.
We have one bid.
Two companies picked up bid.
We had, two companies picked up, plans. One bid. proposed bid. From Chambers and Sons, have their bid bond, proof of insurance. And the total base bid price of $616,642.50. Is that, Brian, is that correct? I'm saying that correctly? And that's with blacktop?
With blacktop.
Okay. $616,642 is the only bid you have. That is within the monies that the Kentucky Department of Transportation has provided for this project. What's your bid?
Motion to accept the bid, Judge.
I have a motion. Is there a second?
Second, and is that without the bridge?
That's without the bridge, but in looking at this, and we can go ahead with, I think there might be enough money in there. We did get another $250,000 in next year's budget
Should be enough.
for the bridge, but there may be enough in here
Yes, be
to
close.
complete it. We'll have to bid it, but, or let Brian see what we can work out, but we'll take a look at it. But what we're accepting today is the base bid of $616,642.50. We have a motion. Is there a second?
Second.
Motion and second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. When can you get started, Brian?
Whatever you want me to.
Start moving dirt. All right, at our last meeting, we talked about, and we were all have been concerned that the state was looking at closing the Purchase Parkway from I-24 into Calvert City. They had a public hearing on this matter at Calvert, and a lot of people was there to voice their disappointment. And, you know, we were just told as a court, matter of factly, that that's what was gonna happen. But I think after seeing all the opposition from people that work in Calvert City, people that live in Calvert City, people that were concerned, they, according to the press, says they're reevaluating their option there. I asked Jeff to draw up a resolution. This is a resolution of the Marshall County Fiscal Court, a resolution opposing the closure of the Julian Carroll Purchase Parkway from the Interstate 24 intersection to Highway 62 in Calvert City, Marshall County, Kentucky. Whereas the County of Marshall and the Marshall County Fiscal Court recognize that Marshall County is an integral part of the I-69 corridor. Whereas the County of Marshall and the Marshall County Fiscal Court recognize that Marshall County benefits in upgrading the intersection of Julian Carroll Purchase Parkway and I-24. Whereas the County of Marshall and Marshall County Fiscal Court also recognize the importance of keeping a roadway open from I-24 to US Highway 62. Now therefore be it resolved that the County of Marshall and the Marshall County Fiscal Court oppose any form of closure of that portion of the Julian M. Carroll Purchase Parkway between I-24 and US 62 in Calvert City, Marshall County, Kentucky. Approved this the 24th, the 5th day of August, 2014. What's your pleasure?
Make a motion, Judge.
We have a motion. Is there a second? Motion and second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. We had, I had a call from Brian Cutzinger, our ambulance director. He could not be here today, but he wanted me to bring this before the court. says, I will be out of town and not be able to attend the meeting. We are needing a new engine for one of our units that is scheduled to be in service for several more years. The blown engine is a Ford 6OL diesel that has been troublesome for us from the beginning. It has had several mechanical issues with the EGR valves, EGR cooler, injectors, and high-pressure pumps. This is common for all Ford 6OL diesel engines. This unit has gone out of warranty by 2,000 miles, and I've contacted Ford in an effort to seek assistance with this issue, but they did not offer any help. We have two options. To fix the unit, which is option one, we call around to salvage yards and find a used 6OL1 diesel engine. This would put us in a position to continue experiencing the same mechanical issues as before, not to mention we will not know exactly what kind of shape this engine will be in or how it sounds. Option two, we can purchase a new engine from Jasper Engines. This company has researched the issues plaguing the Ford 6.0 engine. They have identified many of the issues and found the exact cause of the issues, which has allowed them to correct it. I've heard several good things about these engines. Attached is a quote from Jasper. This is all inclusive, which would include pickup and return of the unit. I feel this is our best option and could allow us to keep the unit in service longer than originally anticipated. The attachment shows everything that is included with the cost and also shows a list of this issues that will have, they have corrected.
Sounds like Jasper people need to meet the Ford people.
Well, this, their quote is $18,224. That's for a new engine to be completed and put in and,
That's from Bailey.
well, that's what he said though was the quote. He just stuck that on there. That's complete running engine, install the kit, wiring, whole 9 yards.
Can I throw another option out to you?
Mhm.
There is a company in Canada called Emergency Vehicle Restorations that you send your vehicle to for 2 weeks. They replace the drivetrain, the motor, and usually the driver's seat. Now, I'm just talking for the Crown Vics, but they can also do any of the Ford emergency vehicles. They do the Crown Vics for $15,000. Brand new drivetrain, new motor, and new driver's seat. So I don't know if that's an option for you too, and I can get you that information to see what, for one of the ambulances, it would cost. May not be cheaper, I don't know, but there is a specific group, and they're out of Canada. You have to send it up there to them.
I don't know if Mark's, I'll pass this on to Brian. I'm not sure
Yeah.
if he's aware of that. I know he wants to get something done, you know, to get this unit back in
Right.
service.
Yeah, I wish he was here where I could tell him that, because I didn't know
Yeah.
he had that issue. I'd have done discussed it with him.
And I don't know when he's gonna be back. He just said he'd be out of town and not be able to attend today's meeting. Let me suggest something, that we give tentative approval for him to work with this company, Jasper Engines, in the event we can't get a better offer from the group Kevin's talking about. And maybe in the meantime, Kev can talk to Brian, we can get with him but give him the go-ahead to spend up to $18,224, which is under the bid limit, to get this repairs done. That way, if we can't get any better deal out of the Canada group that Kev's talking about, he's authorized to go ahead. Does that make sense?
Mm-hmm. I'd make that motion.
We have a motion. Is there a second?
Second.
Motion and second. All in favor of the motion, say aye.
Aye.
Opposed, no.
Where are those dollars coming from?
He has an equipment,
Didn't know what
item
you
in his
did.
budget now.
But that's gonna
With
be,
this being a
that's gonna
substantial
be a big
amount,
hit.
when it comes time to bid for a new ambulance, we may get out of range. It's $135,000. Depending on how much the ambulance bid comes in for, we may have to look at, to be able to purchase that ambulance, to transfer the money into that line item.
Okay.
All right. The Fair Dealing Olive and Aurora Fire Departments have asked, I guess, Russell, they talked to you
Yeah,
They talked to
I'm
me.
thinking Bob too.
Yeah, they
Back-
talked to me and I sent Russell up there to.
about blacktopping their parking lots.
Well, now, these are just these are extensions, at least at Aurora Ross. It's just an extension of their existing pavement, because they vote up there and, gives them more room for parking out in a reasonably close area where the people go in and out to vote. Russell can tell you how large I don't know how large that spot
This
is.
one is about 20 foot wide and it's probably 150 foot long. That's what they're
I
wanting.
mean, they have pavement all out in front of the building that they've done themselves, but they were wanting this extended.
What about,
And then, Ferdy and Olive,
They've got the base coat
they've
down.
got a base coat down, they was wanting to go over the top of it, but they were also gonna add a
Add a
couple
little
of
bit to
strips
straighten everything
to
up.
straighten everything up, yeah.
And it was somewhere figured up to about, did you get my quote? I give you around 13,000,
Yeah,
I think, is what it was for
You
fair
told me,
dealing.
but I've not got it with me.
and what for Aurora?
I don't know. It's gonna have to be dug out and put some rock in, then paved.
Well, I think
We need to get some good numbers.
we probably need to get some good numbers and bring them back to the court. I mean, I don't have a problem with either one of them, but I'd like to know exactly what
Yeah,
we're dealing
no,
with
we
for
gotta get
money.
some good numbers to make sure we know what we're doing.
Because if we set a precedent here, we're gonna do this. We've got other fire districts in the county that may from time to time need a little
absolutely.
help as well. Okay, get us some numbers back on that, Russ. Now,
Okay.
another item, it's not on the agenda, but while we're on the road department, we had one of our truck drivers go for his CDL Fiscal, which is required. Well, when they found out that he had had a stint, they said, well, you're gonna have to have a stress test. Well, the stress test was $510.
$10.
Our insurance would not pay for it. But this was a requirement and ordered by the physician, I suppose, doing the,
It's required by the state.
Does.
I'm sure.
I make a motion, we pay it. He shouldn't have to.
I didn't think so either, Terry, but I thought the insurance ought to pay for it. That's why we buy insurance.
But if they don't, we should.
They won't pay anything to do with the CDL physical.
They don't even pay for our CDL Fiscals. I wasn't aware of that either.
No.
I'm assuming it's probably because it's not a health-related issue, that it's an employment issue, is probably why they're denying.
All right. You have a motion by Commissioner Anderson. Is there a second?
Second.
Motion and second. We pay the bill for that stress test for an
I
employee.
guess if we could whoever, Emily, or whoever, get an explanation at least from our insurance company exactly why. Let's just, is that all the explanation? I'd like to, Greg or somebody to tell us
Okay.
if there's any other, what will they pay for, or
I
what?
had already contacted them about it, and I do have some type of explanation. I don't
Okay.
remember exactly what it was, but I know
Okay.
it's employment related. It's because, that's not something that everybody's gonna have.
Okay.
That's a personal thing that
Specific to
he
that
needs
one.
for his employment, not for his health. But I do have an email that Kim had contacted Humana, and I can forward that to you all.
Okay.
All right, you've heard the motion and second. All in favor of the motion, say aye.
Yeah.
Any opposed, no. Motion carries. We have, 3 terms that are up for reappointment on the Jonathan Water District. Bob, would you like to check with these people and make sure they would be
I can.
willing to?
Which ones are up? I hadn't got them on my list.
Mark Holt,
Okay,
Leon Lovett, and Barry Hill.
okay.
And make sure they're willing to serve, and we'll talk about to them at the next
Do we have
meeting.
another meeting scheduled with them, or what's our status with?
I don't think we've set one yet, Misty.
Okay.
Uh,
I just thought maybe we might do that. Make sure we're all on the right page before we.
Okay. We have 2 members of the Refuse Board whose terms are up. I have spoken with them. They would be willing to serve, Mr. Don Copeland and Bobby Barnett. I would recommend their reappointment. What's your pleasure?
I'd move that they're reappointed, Judge.
We have a motion. Is there a second? I'll second. All in favor of the motion, say aye. Any opposed, no?
No.
No. I will Copeland, but not Bobby Barnett, if you're gonna do them one at a time.
Well, we can. We can go back and do
I
them.
make a motion, we reinstate Mr. Copeland.
We have a motion that Don Copeland be reappointed.
Second.
Motion and second. All in favor, say aye.
Aye.
Any opposed, no? Motion carries. Now Bobby Barnett.
I'd move we put Bobby back on.
I have a motion. Is there a second? Chair will second. All in favor, say aye. Any opposed, no?
No.
Chair votes aye. I vote.
And Judge, that's nothing personal, just for the record, it's based on prior decision-making, as we stated last time this issue came up.
Okay. Animal shelter report. Animals in the pen as of 6/30/14, 79. Animals brought in by animal wardens, 19. Animals brought in by citizens, 82, 101. Total animals taken in, 35 dogs, 18 cats, 24 puppies, 24 kittens. Animals adopted, 70. None in foster care. Animals reclaimed, 5. Animals euthanized, 27. Animals in the pen as of 7/31/2014, 78. Adoption fees taken in were $1,915. Next, we have a transfer, Miss Emily.
I need to move $250,000 from occupational tax administrator to general fund to cover bills and payroll for the next period of time.
Motion approved.
I have a motion, is there a second?
Second.
Motion and a second, all in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. Got an opportunity to review the bills. Do I hear a motion to pay the bills?
Motion to pay the bills, Judge.
Have a motion. Is there a second?
Second.
Motion and second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. Any other business come before the court?
Judge, I had one.
Go
I'm sorry.
go ahead, Al.
Chapel Lane, I wanted to update you all. They've met with Russell and kind of marked off, and they can't really come to an agreement yet. They're still considering it, so that's nothing that we have to deal with at this time. But they have requested a speed limit sign, and I wasn't really sure what the speed limit is on that road. They had asked maybe for some possible extra patrol from time to time, had a lot of larger vehicles traveling at a higher rate of speed according to the residents, and I don't know what that speed would even be monitored at. I'm guessing somewhere around 25, 35.
I'd
to get in.
recommend 25 for right now.
It's 55 unless they said it different.
Yeah, I
And
mean,
you
that
need to
road,
have
it's a
a
very, what's it,
reason to
14-foot
set
driving
it.
surface. You can't even pass safely on it, really, whenever you're meeting a,
I recommend 25.
do we need to do anything other than just accept that, or?
Do ordinance.
You have to do an ordinance.
Don't you
Yeah,
have
do
to
an
read it
ordinance.
twice?
Yeah.
Yeah, we'll have to do an ordinance, but, yeah,
You need
that,
to hear something on the record that justifies setting a different speed limit other than the,
Well, you can't pass safely next to the
13-foot
commercial
road.
vehicles, yeah.
well, when you get to that, when they're,
If y'all are familiar with it, we can have the first reading right now.
yep, here you go.
You gotta plug the name in.
Okay.
Well, you're out on the
It's
ball.
protected.
We are on the ball.
And the
We,
number. Hey, Jeff.
You'll need to ask for a raise. Yeah.
2014 as your rate.
I'll let you put it
Yeah,
in
you
there.
need to pass that on to somebody else after that comment.
You're welcome, Commissioner Gold.
now this is for what?
Chapel Lane.
CHA,
PE, no.
I
There's
get
no
a chance, I'd like
posted
to
speed
read
limit.
that.
It is a dead end, and it,
Chapel Lane.
and there are two businesses that operate commercial vehicles on that road.
All right,
What's the length of that road?
So
Do you
the
remember, Russell?
road, the width of the road basically is the issue.
Yes.
So it should be good enough.
all right, this is a speed limit ordinance. Ordinance number 2014-08. Be it ordained by the Fiscal Court of Marshall County, Commonwealth of Kentucky, in accordance with the provisions set forth in KRS 189-390, Section 5A, based upon the request of affected citizens and after review by the Marshall County Road Superintendent, the Marshall County Fiscal Court does hereby set the speed limit at 25 miles per hour for Chapel Lane located in Marshall County. This is the first reading. Must be published in the Tribune Courier. We'll have the second reading at the next meeting of the court. What's your pleasure on ordinance 214-08?
Just
Make
for
a
the
motion,
record, Judge, the reduced speed is based on what?
And narrow the road,
Width of the road.
width of the road. It's 2,430 feet.
Okay. Now, you have two businesses on that one road that operate commercial vehicles. So people have to sit in their driveway until they pass.
Second.
A motion and second. All in favor, say aye. Any opposed, no. Motion carries. We'll get that published for our next meeting. Any other business? Kev, you had something?
Yeah, this is kind of a bittersweet announcement for me. After a little over 26 years of dedicated service to this county, into this month, David Maddox is going to retire. And we are going to hold a retirement reception for him on the 28th at 1:30 in the circuit courtroom at the Judicial Building. Well deserved. He's put a lot of time in serving this county. You'll never meet a more loyal person in your entire life than David Maddox.
So when are we gonna do this, Kev?
August the 28th.
I'll be out of
It's
town.
on a Thursday.
Yeah.
But,
Well, certainly David Maddox, there's never been a more dedicated, fella that's worked for our county. Whoever the sheriff was, he was loyal. I even had the pleasure of appointing him sheriff for a short period of time. And, he certainly will be missed. I know you'll miss him for sure.
Tremendously.
And the county will. David's just been yes, he started to work for us when he was about 19 years old or 20.
Well, started riding, ride-along
Yeah.
program at that age, but, yeah, he's been, with the sheriff's office, I think since 1988, I believe, and, never went anywhere else. This is, his entire career has been here, and, he has been responsible for a lot of things at the Marshall County Sheriff's Office, and grants, policies that are made, just an all-around sharp individual, and will be missed. But like I said, on the 28th, we are having a reception. We will be sending invitations out as well to a lot of folks. But anybody'd like to stop by and wish him well, we greatly appreciate it.
Absolutely. Before we go, I've given each of our commissioners a copy. Next summer, in the month of June, the Kentucky Changers will be coming to Marshall County, June 20th through the 26th of 2015. The Kentucky Changers is a Baptist organization, but they work on houses, regardless of what denomination you are or whether you go to church at all. If you are low income or elderly and are in need of getting your house painted or repairs, that's what they do. They've asked us to help them, which we'll be glad to do in a way. I think the last time we had them, we provided porta-johns for their job sites, we provided dumpsters, and I think helped them with buying some materials. I don't remember, but we'll look back and see what we did. But it's a real good, they'll have kids coming in here from all over the state, and while they're here, they usually stay at the high school, and then the different churches feed them breakfast, lunch, and dinner. And all the work they do and all the stuff they provide is free. But if you know of someone that would be in need of this service, there is a form in there that you can fill out and just get it to them down at the Blood River Baptist Association office down in Hardin. Anything else? Any other business?
Motion adjourned.
Have a motion. Is there a second?
Second.
Adjourned.